Start. Good afternoon, everyone, and welcome to Lunch and Learn. My name is Christine Lai, and I am the Executive Director and co-founder of Special Education Legal Fund. Welcome to Lunch and Learn with Virginia Blum. This webinar, which is the second, part two, covering the referral process, is going to talk about determining eligibility. So we're really excited for this topic today. Before we begin, I'd like to extend a heartfelt welcome and thank you to our corporate partners. Their generous support makes the webinar program, as well as so much else of what we do, possible. I'd like to acknowledge WellSpire Advisors at the Platinum level and Winston Preparatory School at the Gold level. At the Silver level, we are so grateful for the support of Fusion Academy, Villa Maria School, Eagle Hill School, and Chapel Haven Schliefer Center, as well as American School for the Deaf. And at the Bronze level, we are incredibly grateful to the support of Shrub Oak International School, the Pinnacle School, and the Spire School. Thank you again to all of our partners and friends. We could not do what we do without your support. For those of you who aren't familiar with Special Education Legal Fund, I'm just going to take a moment to introduce ourselves. Special Education Legal Fund was founded in 2018 to provide resources, knowledge, and support to families in need with children in the special education system. Since that time, we have provided over $800,000 in grants for legal and advocacy support to over 220 families across 70 school districts in Connecticut and Westchester County, New York. We do this principally through two main grants programs for families: the Legal Assistance Program, which is an attorney program, and the Advocacy Support Program, which is for advocates. Both of these programs are currently accepting applications at this time. Our next deadline for applications for both of these programs is November 15th, and we notify families that applied in that time frame by the end of the month in which they apply, which for November families would be November 30th. To begin this process, please visit our website to complete the pre-screening. And then if you qualify, you'll receive an email with the application link and instructions about the remainder of the process shortly thereafter. The website is shown below. And also you can go to this handy QR code, which will bring you to the application, the website to begin the application process. Again, our website is www.spedlegalfund.org, and then it's apply for grant. A little commercial for our next webinar. Our next evening webinar is going to take place next Wednesday, October 25th, and the topic is special needs planning. This is one of our most popular webinars. We're really excited to partner with WellSpire Advisors on this topic. We will have Rich Yam from WellSpire Advisors to speak about special needs financial planning. And he will also be joined by special education attorneys Marian Walsh from Littman Crooks, as well as Adrian R. Kontaki from Cuddy Law, and they'll talk about aspects of the special education and transition process. This webinar will be moderated by Michael Delgas from WellSpire Advisors, in case anyone is afraid of me talking about the special needs planning process. Join us next Wednesday. This is one of our most popular webinars, and we'd love to see you all there. And I also like to, to mention our next in the Lunch and Learn series with Virginia, which take place Tuesdays at 12 noon, is going to be on November 14th. And that webinar is going to be a great one. It covers the topic of prior written notice and IEP language. Again, you can sign up for this webinar as well as all of our webinars by clicking on this QR code right here, and that will take you to the Eventbrite page where you signed up for this webinar. So welcome today to Virginia Blum, who's presenting on this topic. Virginia, if you are new to this series and to our webinar series in general, is a special education advocate at Connecticut Education Advocacy, as well as a longtime friend of SELF's and a board member of Special Education Legal Fund. But most importantly, she is a mom. She's a mother who navigated the special education system on behalf of her daughter who carried an IEP. She's a regular guest on our evening webinar series, and we could not be more pleased to welcome her, especially on this topic today. And finally, because it would not be a webinar without a disclaimer, This webinar panel is presented for informational purposes only. This webinar is intended as a resource for families who are navigating the special education system in Connecticut or New York, and it is not intended to provide legal support, advice, or assistance to any particular individual, nor is it intended to replace the advice and counsel of a qualified special education attorney. Families in need of legal advice, support, or assistance should contact a special education attorney licensed to practice in Connecticut, New York, or the state of their residence to discuss the specific needs of their individual student. This webinar should not be construed as an endorsement by Special Education Legal Fund or any of its representatives of any of the participating panelists in this program. And with that, here we are with Lunch and Learn, the referral process, determining eligibility.
So hi, everybody. I'm really excited to pick up where we left off in terms of the second part of the referral process. So this topic kind of picks up where we're creating and allowing the school district to evaluate your child to determine if they have a disability that requires specialized instruction and support. So the first part of this process is to create the evaluation plan. That happens at PPT 1. So that's part of the referral. If you get, once you come to that meeting, if the school team and you think that they need further information and evaluations, we develop that plan there. The district has to obtain consent to do the evaluations. They need to conduct the evaluations, and then going over the results and determining eligibility happens at the second meeting, PPT 2. So this is what we will be talking about today. Next slide. So how do we create the evaluation plan? And many parents sort of feel like they're not, they kind of sit back and let the school team, recommend things. And certainly that's part of it. But you need to remember that you, as the parent, the guardian, are a valuable member of the team. And you need to ask questions and understand what is happening at each part of this process. So as you're moving through this discussion and the team is recommending different providers that do different evaluations, you need to ask questions such as, what is this going to give us? What information? What does this test measure? What areas are you planning to assess? If my child has a speech delay, you want the speech and language person to be giving you a direct measure for speech and language. If your child has, motor planning difficulties, maybe it's the PT and the OT, along with the school psychologist, an academic evaluation. So you really want to make sure that all areas are looked at. You can and certainly should ask if, does the evaluator have any experience, or, are they a registered, licensed practicing professional in the field that they're going to evaluate? And I always recommend, as part of this process, that we have observations. So you want to look at how the child is performing, not only in the classroom, but also in an unstructured setting. So if there's a language concern, we're looking at every environment. And that should happen across the people that are conducting the evaluation. So not just the school psychologist that's doing an observation, but also maybe the speech and language. But all of that's up for discussion. And you should understand what is happening and what the team is proposing to look at the start of this process. The law says that the evaluations need to be comprehensive. They have to use a variety of assessments, observations, and tools to ensure the student is fully tested in all areas of suspected disability. So that's where you're pulling in some of the related services if you have a communication concern or a motor concern. Next slide. So who is on the evaluation team? Who's sort of helping make this process? There's always an administrator, somebody that has authority to make decisions. There's a school psychologist and somebody that's looking at that level. The regular classroom teacher is an important component. Because we're talking about special education and the need for special education, there should be a special education teacher. The parent is part of this team. So that's a very important piece and you should know that going into this, that you are part of the team. So you can ask these questions. You should understand your role and you know your child the best. So a lot of times children hold it together in school and they come home and they fall apart. All of that is critical information to discuss at a team. And then any related service provider that's helping. So that can be the speech and language pathologist, that can be an occupational therapist, it can be a physical therapist, it can be a BCBA if there's behavioral issues. So any of those people are also part of this team. Next slide. So once you've sort of agreed to and you have information about what we're going to be testing and who's going to test it, the school district has to give you a consent form. So this slide has an example of the consent form for Connecticut. And you can see what's on here. This is a very important document. The school cannot proceed with any of the planning, any of these important evaluations without the parent giving written consent. So that's why at the bottom, you have to sign this document. If you do not sign this document, the school cannot test your child. It's important to note that all you are agreeing to in this document is that you want your child evaluated. So you're agreeing to what they're going to do and who's going to do it. So in that middle box, the test or evaluation procedures, the area that's going to be assessed, who is going to evaluate. The school sends you this document with the assessment plan. Sometimes at PPT1, they've kind of created and you sign it right there. Other times they will hand it to you. You can certainly take it home and read it. You have to return this document. If you do not return it, it is the assumption that you are not in agreement with the testing. And again, the testing cannot happen without you signing it. So they also have to document, if you do not return the form, that they've tried to get the form from you. Because again, in the agreement and the school district saying that they want to test, they want more information to make an eligibility determination. So they are obligated to try to find children that need special education and supply that to them. This is really important. And, again, I can't stress enough that you should read it. You should understand what you're signing, but you need to either ask questions or sign it within the timeline. Next slide. So this is sort of the timeline for special education process. And it starts with the receipt of the referral. So that is when you notified the school that you wanted PPT1. It is not when you sat down to have the first meeting. So when you sent the email that said, I want to refer my child for special education, this timeline starts. And you can see it has to be completed. The entire process has to be completed within 45 school days or less. So it is really important to document and know when you made the referral date, because that is when the clock starts ticking. So what the school has to do and what you all have to do is you send the referral, they send you a notice that says we're going to have this first meeting. You have the first meeting where you discuss why you're at this meeting and what the school team needs to do. If the school team agrees that testing needs to happen, they will develop it at PPT1, and you have to give your consent for the evaluations, which we just showed you that form. Once the district receives the consent form, the timeline restarts. So again, if you delay in sending in the consent form, that is stopping the process. And it is also very clear that you have 10 days from the receipt of the consent form to return it to the school. Let's assume that you signed it, you move forward, the school district received it. They have to then conduct the evaluations. And a lot of times this is a lot of testing. So the sooner we can start this process, the better in terms of giving your child an appropriate time to complete all this testing. They do the testing, they have to provide you with another date to have a meeting. That's the meeting notice for PPT2. The parents also should receive copies of the evaluations prior to the meeting. So that's a really important part of it, and it's delineated there. It says parents are provided with initial evaluations reports a minimum of 3 days before the PPT. Again, you're a valued member of this meeting, and you need to read and process this information about your child to be able to talk about it in a reasonable way. You have PPT2, and that is when the school district will walk you through the evaluation measures. You can have a conversation and a discussion, and you determine eligibility. At that meeting, after you've made a determination for eligibility, the school district is obligated to give you an offer of FAPE, or free appropriate public education. What are they going to do? How are they going to address the deficits that now require special education? And the IEP must be implemented. So in that 45-day school timeline, a lot of steps have to happen to get the services and supports your child needs. Next slide. So I just wanted to kind of briefly talk about the categories that are eligible for an IEP in the state of Connecticut. And I put this in there for a real big reason, in that it's not just about my kid has good grades. So absolutely, having a learning disability and struggling to learn to read, write, and do math is part of, the reason to get an IEP, but that's only one. And in Connecticut, you have dyslexia broken out. So maybe 2 categories of these 15 categories. So we can find a child eligible for an IEP under autism, under being deaf and blind, having a developmental delay. Please note that category is only appropriate if the child is very young, so from ages 3 to 5. An emotional disability, a hearing impairment, multiple disabilities, which can, so if you are struggling with, my child has autism, but also maybe deaf, we might want or feel like that's more representative of the primary disability. An intellectual disability, a gross motor disability impairment. We talked about a learning disability, speech and language impairment, a visual impairment, a traumatic brain injury, and then other health impaired. And then there's a subcategory also considered other health impaired, ADD, ADHD. The ones that I put asterisks beside are the ones that the state of Connecticut has actually developed worksheets that help teams kind of go through those particular categories to determine eligibility at an educational level. So sometimes people can say, my child has a medical diagnosis of autism, but does not have an IEP. And that's because the team has determined that while the medical diagnosis may happen, the educational requirements for an IEP have not been met. Next slide. So I wanted to be really clear about, what you should do before PPT2 as a parent and what you need to do at the meeting. So before the meeting, you want to see the evaluations, and you want to have those at least 3 days prior to the meeting or sooner. You want to read through those evaluations carefully, highlight them, have questions ready. Like, if you're confused about something, what does a score mean? If you see a discrepancy between measures. So, the expressive ability to communicate is a lot lower than the ability to understand and receptively. That may be a question. Some districts offer to sit down with parents prior to the meeting. So if the evaluator did a evaluation on a speech and language, the speech and language pathologist who did the evaluation may offer to sit down with you prior to the PPT2. And I always think that's a great option. It's a great opportunity for the parent to, not an informal meeting, just to be one-on-one with the evaluator and to ask the questions about what the tests mean, and how the evaluator is interpreting some stuff. And so I always welcome a sit down prior to the meeting. And it's nothing to be scared about. And it's just good information and a way to kind of be together and understand the process. So all of that you should be developing prior to the meeting. At the meeting, what happens is, after introductions, the specialist who evaluated your child will kind of go through briefly the evaluation. If you have questions, you certainly should ask them at that time. And then you discuss eligibility as a team. So what does all of that information on your child mean? And does the team feel, given that information, that an IEP is necessary? If there's a state guideline, so if you're looking at autism or speech and language impairment, they should be reviewing that state form at the meeting. If they don't offer to do that and you feel that your child has a speech impairment or has autism, you can certainly request that they go through that document with you. Again, you're part of that meeting. So that's why it's sort of important to do your homework up front. You should have, looked at that form online so that you understand the questions in the boxes. Because again, you're part of making that eligibility determination. If the team decides that there is enough information and that there is a disability and it requires specialized services and support, they should be then moving from that conversation to what is your IEP going to look like. And all of that happens at this second meeting. So it is a long meeting. It's a lot of information. And it's a lot to get through. I do not think it's something that you can do in 45 minutes. So if the meeting request comes and it's not giving you enough time, you might want to also say, listen, that's a lot to get through. I think we need at least an hour, or I think we need at least 90 minutes. Those are reasonable requests, but you want to make sure you can have a fluid conversation and everything can happen. Next slide. So the team found my child eligible for special education. Now, what do? We developed the IEP. The IEP lists the present levels of concerns. It should have all of the evaluation results in it. It should have specific goals and objectives that address all areas of deficit. It should have oh, sorry. Thanks, Christine, for moving.
I know there's an extra slide in here. Apologies.
That's okay. It should also have direct services. So who's going to support my child in getting those skills? Any accommodations like preferred seating, extra time to take tests, and that's sort of the framework of the IEP. But note that the IEP is not, you don't just create it and it can never be changed. It's a living document. It can be changed at any time throughout the year. And a lot of times if I'm at PPT2 and we found a child eligible, because we can't have that information in advance of the meeting, because that would be predetermination, I often say, listen, let's do the best we can. Let's, quickly talk about the buckets of where we need to be in terms of what goals we should be addressing. And let's agree to meet back in 45, 30 days after we've implemented this IEP to make sure we did everything, make sure the child feels supported, make sure you feel supported, make sure you have time to read the document. So that's another way to kind of move the process forward, but still, and get this IEP in place, but still have a meeting set up to really kind of process and listen to your child and make sure you have the right plan and program for your child. The other thing that has to happen is, again, you have to sign consent for your child to enter special education. This is critical. The parent has to agree to it. If the parent does not sign consent, your child is not able to get the supports and services that the school team and you have felt are important in their IEP. I want to make it clear that you are not consenting that the IEP, the goals, the objectives, the services are all what you think should be. You're only consenting that your child should receive special education. So again, because the IEP is a living document, because we can change it throughout the school year, your consent is about, yes, I agree that my child should receive an IEP. Not that the IEP is fully capturing everything that I think they need. So I make that distinction because I think that's important, and it's critical that you sign consent for the IEP to be put in place and your child to receive important services. Next slide. So what happens if you don't agree with the evaluation process or the outcome? You should come to next meeting on prior written notice, but you want to make sure that all the tests and assessments you agreed to were actually done. So that's why when you ask the team what they were going to do, you have a record of that, and you want to make sure that they actually did everything they said they were going to do. During the meeting, you should express specific concerns to what you're questioning. You know, if your child has attention deficit disorder, but the school team did no direct measures to assess attention and relied solely on rating scales, that could be a problem. So you really want to express, you know, what you see and make sure that you're responding to and entering into the record your disagreements. So you also want to document the meeting that you disagree with the school team's decision. So if the school team says, listen, we've looked at all this information and we don't think your child qualifies for an IEP, and you as the parent feel differently, you need to state, I am not in agreement with the school team's decision. So you feel that there needed to be an IEP, the school team didn't, and you're part of that team. So a lot of times when you read the minutes back, they say everybody was in agreement. But if you, as the parent, thought your child needed an IEP, you are not in agreement, and you're not leaving that meeting in agreement with the team's decision. And you need to clearly state that. And the other thing that we could spend another whole series on, but is you have a right to an IEE paid for by the school. This is your child has to receive comprehensive evaluations. It's the school team's job to do that. If you do not feel that all areas were evaluated or that the school team completed a comprehensive evaluation, you can make an IEE request. You can make it at PPT2, or you can leave PPT2, think about it, and make it in writing, because this request does not have to happen at a meeting. So you do have to, though, make it in writing. It's usually in an email. And you would email the vice principal or the administrator that was in the meeting saying you're not in agreement with the results of the evaluations or the results of the lack of an IEP, and you're requesting an independent expert in these areas. So you have to, again, be very specific which evaluations you're disagreeing with and which ones you're requesting have an independent evaluation. The district has 10 business days from the receipt of the IEE request to either grant the IEE and say, yes, we agree, we need more information, or they can deny that request. And when the district denies that request, they are obligated to file for due process to defend their decision to not allow the IEE. And that's a very brief conversation on IEEs. It's a very complex piece, but I felt like it was not in, in going through this process, we had to at least touch on your right to request an independent evaluation if you're not in agreement with the district's evaluations. Next slide.
That's all the slides that I have.
Okay, well then that's not all of them.
Oh, that's unfortunate.
That's okay. Well, I have my, oh wait, no, that is all of them. Sorry.
That's all right.
I know, and it's 12:30, so
I know. Thank you so much, Virginia, for this really just tremendous presentation. I had a couple of questions. And then obviously, if anybody in the audience has a question for Virginia, please feel free to type it into the chat, and I will address those, on the presentation. So going back to, again, this is a tremendous and comprehensive explanation of the process. And obviously in any one of those slides, we could encompass an entire other presentation, but I wanted to start back out on the evaluation team. And you had mentioned these, administrator, psychologist, classroom teacher, et cetera, as part of the classroom team. Would there be other people that could attend the meeting on behalf of the parent? And can you talk about who those types of people might be?
So sure. I mean, again, you're allowed to invite anybody that has special knowledge, or can share information about your child. So if you are working with a private therapist, if you're working, or your child has an occupational therapist that supports regulation, any of those experts can come to the meeting, or they can write a letter supporting the need for an IEP. So sometimes instead of having everybody come, a way to kind of like provide information is to have your experts they're supporting your child outside of school send a letter. I usually recommend that letter includes sort of the experts' credentials, and their relationship with the child. So how long have they seen the child? What are they supporting? What do they see in the private sessions? And what are their impressions? What are their recommendations? If that expert outside feels strongly that your child requires an IEP, saying it like that, I'm in support of, that this child needs an IEP is a strong statement. It's another piece of the puzzle in terms of helping the team determine eligibility. For instance, if I have a child that has a psychiatrist that's getting medicine for attention deficit disorder, that's a very important piece of information that should be shared with the school team. So I think we sort of talked about getting letters together at PPT1, but certainly through the process being as transparent and open as possible, and sharing with the school team your private work with the child is critical in making decisions. So good question.
Great point. That's a great point about the letters, because obviously sometimes it's hard to get, all of these people in a room or on a screen together. And a letter is a great way for a professional to provide testimony, for want of a better word, on behalf of the student and have that voice be heard. So my next question relates to, the testing itself and consent to evaluate. Is there any instance in which a school can test without your consent?
I don't think so.
Okay, I wasn't sure.
I think
That might be something to explore further, but
again, I think that the bigger sticky point on that is school teams sometimes write the consent form very vague, and they don't tell parents. We can get to that planning of the evaluation, and it can be very vague. We're going to do a speech evaluation. We're going to do a psychological and an educational, and the parent says, "Great," but you're supposed to make informed consent. And you saying great to all that without really knowing, are they, if you're worried about your child, reading and having dyslexia, are they really giving you enough information to make that determination? And I would argue that a single measure in an academic front on that is not enough information. So, again, it's hard to kind of talk specifics, but I just recommend that you know what you're getting and you're very clear. Some districts are doing their consent forms different. So I have some districts that actually physically now are writing every test they're doing. And that's helpful because then you can look at that piece of paper and know exactly what tests you should be getting. And other districts are not. They're just writing direct measures for speech and language. So a better way to think about that is to say, well, what areas in speech? If I'm worried that my kid is got articulation or is not saying the letter sounds right, I want to make sure we're looking at articulation. If I'm worried about
that's a different test than pragmatic language, or
that's what I was going to say. But if I'm worried about social communication, we need to be looking at pragmatics. So you just a way to write it vague would be I want it to be on receptive, expressive, pragmatic, articulation, and that would be a lot in a communication evaluation. The other thing that I will briefly say is some school teams say, listen, we want to keep the consent vague in case we want to do more testing than we've discussed right now. So like, I all of a sudden I'm doing some testing and I see another area, I want to have the flexibility to do that. My recommendation is always to say to teams, listen, we want you to test what you think you need. So we at no level will block or stop testing, but however, we want to know what you're doing. So let's start with what we think right now. And if you want to change it through the process, then just at least send me an email and let me know what you're going to look at next. Like, this is my child. This is a critical piece of information, and I need to know what you're doing. So I think that's a very reasonable request. And school teams usually say, oh, absolutely. Like, but if you don't say
what
that,
each test is for.
Right. And if you don't say that, then they're off on, maybe they're doing something that you didn't know about. And so like, just again, the law is that you're making an informed decision, and information is helpful in making that decision.
Yeah. I mean, I think a lot of parents, at least, some of the parents that I talk to, sometimes will be, taken aback or intimidated by, lists of specific tests because they don't necessarily know what each test does or is supposed to measure, and I think that what you've just said is a valid, is a valid way to respond to that, which is, I'm sorry, I don't know. I'm not an education professional or a psychologist. What do each one of these tests cover? And what are you hoping to learn from those tests? I always obviously think it's better, to be, more specific is better than less specific. But I think that's also a way to, that helps in that process. So that is, that's super advice. I've got a few more questions. I could go on this all day. And then there's also one question in the chat. So I will get to those in a second. My next question is on the timeline. Whose responsibility is it to manage the timeline?
School district.
But if they miss the timeline,
so again,
what happens?
So while they're out of compliance, you have your due process rights, you have your state complaint rights. The biggest thing that I run up against is not they're going to complete it in 45 days, but where they're going to start the clock ticking. And the clock starts ticking at the date you sent the email saying, I am making a referral for special education. It is not the date we sit down for PPT2. So in an egregious case, we sat down to PPT1 30 days after we made a request for a referral. That's inappropriate. And they only have 15 days to do all that. And I'm not feeling very collaborative to extend that, because that's my right. My child has been missing critical support, and I'm not feeling flexible to do that. The one sticky part about it is if you make a referral and it's close to the end of the school year, teams do not have to test over the summer. It's kind of sticky in Connecticut. I'm not going to get into the legally, but they can somewhat push pause because it's 45 school days. Please do note, parents, that they have extended school. They are offering and have staff this summer, and you don't have to press pause. The federal law states that this process has to happen within 60 calendar days. But again, that's a little sticky.
And just to point out that, when the school, or if the school, I should say, is out of compliance on the timeline, you can't necessarily depend on them to tell you that they're out of compliance.
Oh, they're never going to tell you.
What I meant in this question is that it's important for parents to keep an eye on the timeline, know what your sort of markers are, know when you started, know when it's paused, know when it starts up again, because they're not going to tell you that they messed up.
They're definitely not going to tell you. And that's why, sometimes just knowing that going into the first meeting, if you determine that you need to do testing, you should have in your head when the next PPT needs to happen.
Right.
And especially if it's taken you a long time to have that first meeting, it's the clock is ticking. And I often have, and I often take that slide that I had with the Connecticut timeline in there. So you can say, I'm confused. It's not PPT 1. Here it is.
Yeah.
So
here I've written the dates next to it.
Right. So again, that is a good piece of information. And then you can follow up in an email, everything in writing.
Perfect. My next question, gosh, I could go on all day, is on the disability categories in Connecticut, and the slide that you listed, which had the, sort of the 15, or 13 to 15 primary categories. I got a lot of questions from parents when on the topic of, the medical diagnosis versus, the classification that I think you covered very nicely. What if a student has a medical diagnosis that's not reflected in the educational classification? How do you approach that?
You mean like
say they have an autism diagnosis, but the classification is OHI, other health impaired. How do you address?
So again, if PPT, if we're determining eligibility and we're arguing that the student could have a classification of autism and other health impaired, for example, the important thing that I would say from that is, number one, the team is recognizing the need for an IEP. Great. Right. We're in agreement. We all think that the child needs an IEP. If the school team says to the parent, look, we can meet the qualifications under autism, or we can meet them under other health impaired, I find usually school teams defer to what the parent what the parent thinks at that time. And so if there's two categories that both fit, that everybody's in agreement for, you can probably tip the scale if the parent feels strongly that it should be. If the school team is telling you that your child does not qualify under the educational category of autism, but would qualify under OHI, my recommendation would always be to take the IEP. And then to just document on prior written notice that you're not in agreement, that the primary disability, is not autism, but you are in agreement that we should have an IEP and you will accept the OHI IEP. So again, you want that umbrella to be happening. The other thing, just to know is the school team, just because we pick a primary disability doesn't mean that all areas are not supported. Right. So if we're picking OHI, but the child needs pragmatic speech support, we should still be supporting the child with
ABA or
whatever it is. So I don't think we need to get super hung up on the primary disability. That said, it is the first thing I look at when I'm reading an IEP. Absolutely. And the first thing that a teacher or any person that's supporting your child is looking at. And I do think if I'm looking at an IEP and it says ADHD, and I'm seeing goals and support that really speak more to specific learning disability, I am questioning, why are we doing that? So if attention, a lot of times attention is something that happens to lots of students, but it may be a comorbid disability to a larger picture.
Mhm.
So, but again, we can change the primary disability, throughout the process. We can change the goals and objectives. We can change the services. We cannot redetermine eligibility. So it is important to take the IEP.
Absolutely. Perfect. So there are I've got two more questions. I've got one more question, and then I'm going to ask the
Sure.
question that's in the chat. How long do you have to request an IEE? That is going to the,
Actually, that's a great question, and I meant to mention it, so thank you. You actually have up to 2 years.
Mhm.
And so it gets a little sticky at 2 years,
Okay.
but you don't have to. What you
From
can
the
do
date, from when the school evaluation was done.
from the date of the evaluations.
Hmm.
So, because you're disagreeing that the evaluation, so usually the evaluations correspond to PPT2.
Mhm.
So one strategy could be that you leave the meeting and you didn't get the IEP, and you wait, and your child continues to struggle, and then you say, I'm now, like, we need an IEP.
It's 6 months later.
Yeah.
We're still struggling, and I need an IE. I need an evaluation to, independent.
We made a mistake at PPT2, like, basically. I will say this. The other thing is, if you made a referral and you went through this process and you didn't get an IEP, and then 6 months later you're having problems, and the school team comes to you and says, we need you to make another referral. No,
No, same
you
referral. Yeah, same.
it's the same referral, and you did the wrong thing. I told you did the wrong thing, and now we are requesting an IEE. So we don't need to keep allowing the districts to do re-update testing.
Restart. Yeah, to restart.
Now, if it's been, a year and a half, maybe we do. So there is some gray area in the 2 year. So, but,
Yeah.
but if it's 3 months or 6 months, it's not really gray. And they didn't look at all areas, and
What would you say if the school, it's been, 2 years, let's call it, and you ask for the IEE, and the school says, oh, you know what, because it's been 2 years, why don't we just move up the triennial instead? Is that a valid,
Well, you wouldn't have a try if you didn't have an IEP.
Oh, that's right. We're on eligibility. Sorry.
So, yeah.
That's right.
And I would say if it's 2 years and we want to retest, I'd probably be collaborative and retest, because a lot of development happens at any stage of life.
Absolutely.
So if it had been 2 years and
those are like, huge,
then
huge
I would
developmental.
Yeah.
So I have a question from one of the guests. How many times can a child be evaluated by the school? If, and this kind of goes to what you were discussing before, how many times can a child be evaluated by the school if the student had been found ineligible in a previous referral and the parents didn't ask for that IEE?
I mean,
prior eligibility meeting. Is there a limit?
There's not a limit. Every fact is, and every case is unique. So that's a hard question to answer for me, because there may be a reason that we would let them test, and there may be a reason that we wouldn't. It's sort of depends on a lot of things. But what I would say to you is, if it's in the same school year and you make a referral in October and you go through the process and you don't get an IEP, and then in, I don't know,
February,
right? The wheels are off, and I would ask for the IEP. I would not allow the district to do more testing.
Retest. Right.
Because again, the difference between those evaluations is that an independent person spends a lot of time developing concrete recommendations in terms of what does this information mean and what do we need to do. And school teams, leave that blank and say recommendations to be discussed at PPT. So, you know, if we already had that and we didn't get the outcome we thought we needed, what trust and faith do I have that I'm going to
In
go
that
through
old testing.
again,
Right.
and we're gonna make a different decision with the same people that were in the room in October.
Right.
So that would be my thing. I will, you know, as a caveat, IEs are great, but it's gotten very difficult to get them awarded. And so it's not a slam dunk to get them anymore. And so, you know, it just depends on a lot of factors as to what the evaluations look like and what we're hoping to achieve, and, you know, what discussions we're having outside of PPT and how comfortable we are with those discussions.
And I would absolutely reiterate that it is, you know, has gotten considerably more difficult for that, you know, for families to request and receive an IE, certainly relative to when, you know, when we started, when Self started up 5 years ago. So I definitely, you know, see that as a change that we've seen in the last few years. I want to thank everyone for joining us today. I want to thank Virginia for this tremendous presentation, wrapping up our discussion on the eligibility process and the referral process, I should say. Please join us next Wednesday, October 25th at 7 p.m. for a discussion with Wellspire on special needs planning. We look forward to that. And our next Lunch and Learn with Virginia Blum will be on November 14th. Again, that's a Tuesday at 12 noon. Hope you can join us there. And thank you again, everyone. Good night or goodbye. Sorry.